Mm. So now we start again. Hello, my viewers. I wish you well. I greet you and I wish you well. Thank you for joining me today. Just as we discussed last week, we'll be having a online live presentation, and we're going to be talking on introduction to property law. Today, I'm going to take you around in all that you need to know about property law practice in Nigeria. And we're going to start with introduction to property law. I want you to stay tuned while I take you bit by bit. Most of us have been asking, they have been looking for opportunity to meet with a property lawyer and ask some questions, whether you're a student, whether you're a property developer, whether you're a property investor, whether you're a property professional dealer, either estate surveyors and valuer, estate agents, land surveyors. Remember, once you have a play in real estate industry, you can always stay tuned. And this is coming up every Tuesday live on Facebook, Instagram, and YouTube. So by next week, we'll try and incorporate LinkedIn and TikTok, just to take you through some things that you just need to know about property law practice in Nigeria. I mean, the law, they have, we'll just ask what is this area all about. But once you are into a property practice, you will be able to have a little knowledge about property law. So property law in Nigeria is a complex and dynamic field, essential for anyone involved in real estate transaction. Once you enter real estate transaction, you must always need it. Understanding the fundamentals of property law is a very crucial thing you need to know to be able to safeguard your property rights. Title is very important. So this presentation will provide you an in-depth introduction into property law in Nigeria, and it covers key aspects such as legal framework, types of property ownership, land tenure system, and the roles of the various stakeholders in property transaction. Who are those stakeholders? Land agent, land surveyor, estate surveyors and valuer, land surveyors, um, lawyers, property lawyers, and general lawyers, and so many of the other property mortgagers, the mortgage brokers. There's a lot of people that they undertake, property investors, property developers. These are the stakeholders in property transaction, and they need to understand all these things and know how it works, and know their function. So this presentation will take you around and explain to you what all these people are going to do for you in property transaction. Then the property ownership, the different types of property ownership. You need to know more about that. What do you know about property ownership? What do you know about land tenure system? All these things, and then legal framework. What are the law covering real estate transactions in Nigeria? So those are the things that you will be asking yourself, how to go about all these things. So now, just to take you further to that, we'll be talking about the property law, the legal framework. The property law in Nigeria is governed by various laws and regulations, and both at both federal and state level. So the most significant ones are the ones we are going to talk about. So now, the most important law in real estate transaction is the Land Use Act. Land Use Act, what is the Land Use Act all about? This act is a cornerstone of land administration in Nigeria. It vests all land in the state in the hand of the governor of the state, and who holds the land in trust for people. The act categorizes land into urban and non-urban areas. So non-urban areas are known as rural area with different administrative procedure. The lands in urban areas are being administered of the state, while that of local government is being administered by the local government authority. So like Lagos State. Lagos State has declared all part of Lagos State as one region. So most of the administration of the properties are done at the state level and is done by the governor. And the governor of the state is holding the land in trust for the people of the state. So whenever you want to buy property, you go back to the governor of the state to get a certificate of occupancy and the governor consent. So by the virtue of section 1 of this Land Use Act, it vested the land in the state government, and the state governor of that of local government for the rural area. And the section 22 of the Land Use Act also vested in that any transfer of ownership from Mr. A to Mr. B, he must sought and obtain the consent of the governor of the state. So those are the very important thing you need to know. So the next important law that governs the transaction of real estate, private transaction, is Conveyancing Act of 1881. Most people don't know about this Conveyancing Act. This Conveyancing Act of 1881 takes care of most part of the eastern states. All southeastern states are under Conveyancing Act state. What they use is deed of conveyancing. So you need to understand that, because when you see some document from Lagos or that of Anambra, Oka, Imo, Enugu, Ebonyi state, you'll be wondering why are they using deed of conveyance there. Even Imo state, they are using power of attorney to transfer ownership of property, but you cannot do it in Lagos state. So those are the things that you look at. So the basic thing there that the Conveyancing Act states, these are old laws made by British government then. In fact, they brought it to receive English law that is applicable, but most of these laws have gone into aberration. That's are laws in existence but they are not being followed. So this another law is also property and conveyancing law of Conveyancing Act state. Deed of assignment, deed of assignment. All these things you see people using in Ogun State, they are using land purchase agreement. Please note that land purchase agreement is the same thing with contract of sale, and it's not in any way a replacement of deed of assignment. A proper document for you to transfer ownership of property is deed of assignment. Deed of assignment in the western state, because it falls under the PCM state. So these laws apply to all the states in the southwestern region, and it provides a comprehensive framework for property transaction. The next one that affects property transaction is Nigeria Urban and Regional Planning Act. It regulates the land use planning, development and control, urban planning, and ensuring property development complies with approved plans and regulation. If you go to different states, they have different agencies covering all these things now, like LASPA and some other states, they have their own different names. Those are the agencies ensuring that the lands they are going in accordance of the urban and regional planning of the states. So those are the very important things. Then others are just like normal state laws. The state laws that are in operation in different states, like Lagos State, they have their own internal state laws. Each state in Nigeria has its own laws and regulations governing the land administration and property transaction. So these laws may vary significantly from one state to the next. So different states in Anambra State, they have their own laws governing them. In Lagos State, Ogun State, FCT. So all this understand that they have their different ways. Then the next thing we're going to look at, after understanding different laws governing the property transaction, there are some other ones like a mortgage and property law, but all these ones are not important, like because you cannot see it only if you are doing a particular transaction. There are some of them waste art. Waste art is when you are drafting away all these things. So then some law governing probate, administration of the estate of disease. When somebody died, you cannot just touch the property of the person without applying and obtaining the letter of administration. For somebody that died in intestate, when somebody that died with a will, you will apply a letter grant of probate. So, but those ones I don't want us to digress towards. A time will come when I will talk about that. But one thing I want to let you know that this is going to be educative and informative series, and I would like every one of us to engage. If you have not started following, you can follow us on the Facebook, Instagram, and the YouTube channel, Chaman Property Lawyer. I decided to use the name Chaman Property Lawyer because it's a extension of my business, Chaman Law Firm, Chaman Properties. So, and as a lawyer, so and I believe that the name conveys the message that I want to pass to my audience. And who are those my audience? Those in property transaction, those that wish and desirous of investing in property, and those that want to study courses related to property law, property transaction, real estate. Most people, we all know that real estate is now the gateway for unemployment in the society, and I always encourage anybody, if you look for a job, you don't see job, enter into real estate. What you just need to start real estate is common sense. With your common sense and your mobile phone, you can be able to do well in real estate and all those things. So and this my presentation is coming up every Tuesday. Every Tuesday in the evening, we'll just have to chat together between 8 o'clock to 10 p.m. We'll just have a chat, but we schedule it to be 8 to 9, but sometimes we may have some delay in the process. But stay tuned. If you are not following the channels, you can click on the subscription button and also the notification so that you get notification whenever we drop some content on the platform. Stay tuned, and while I take you through different types of property ownership. What are different types of property ownership? What do you know about property ownership? In Nigeria, property ownership can take several forms. We all know that, and each of it has its own legal implications. If you don't know the type of ownership you have, you will just presume. The first one I will talk about is what we know as free ownership. Free ownership by the virtue of the Land Use Act 1978. The free ownership is not what it ought to be. You are not fully owner of that property because government has already, by virtue of the section 1 of the Land Use Act, government has vested the power on the state governor where the land is situated. So, but the free ownership is just about when you are born, you grown up from your village or from your community and from your father ancestral hereditament or the property that their father inherited and back to you, to your family members, all this thing, they call it free ownership. But in as much as that, if you want to obtain any document on that land, you must go back to the state governor. This is a common concept where owner has an indefinite ownership right over the property. So a freehold, in fact, land use act abolish it. But based on the fact that under section 30 of the land use act, the government still made it that those that have been in physical possession of the property as of the time the law was enacted, that was the Land Use Act 1978, that was March 28, 1978. As of then, you are deemed to have the right of occupancy. So you are deemed to be the owner of that property. So by so doing, if you want to do anything, you now apply to government for what they call private CFO. They call it a deemed grant, deemed grant consent. So those are the things that you are going to apply in that regard. So you need to understand that these freehold interests are often acquired through inheritance or purchase, and they provided the owner provided that you have the land ownership as of before the enactment of the Land Use Act. Then the second ownership um, of land you can talk of now is the lease ownership. Lease ownership, leasehold. They call it leasehold. You are the owner of the property, but for a certain period of time. The difference between that freehold and the leasehold is that freehold is permanent, while leasehold is temporal. In as much as temporal, it may be of a very long period, usually for 99 years. When you have a certificate of occupancy, what it means that government give you rights to occupy that premises for 99 years. After that, the thing will be reverted back to the state government. So please take note that leasehold interest has what is called reversionary interest. It will revert back to the original source. That's the government. So that's different between that. Under the Land Use Act, individuals and corporate bodies can hold land for a specific period, typically for 99 years. And through this lease granted to them by the state government, so you need to understand that leasehold confers right to use and enjoy the land for a lease period. You need to understand that, and subject to term of lease agreements. There must be a lease agreement in respect of that. You pay your rent, you have some things you have to pay, you have some terms and conditions that will be attached to leasehold. Note that certificate of occupancy is a leasehold, is a lease which you are holding for a term of year. You need to understand that. So it's a leasehold. Then the next ownership you think of is customary ownership. What is customary ownership? Many parts of Nigeria still recognize customary land tenure system, where land is owned and managed in accordance with local customs and traditions. Customary ownership is typically communal, with community and family head holding the land in trust for the members. Communal ownership, that's the same thing with customary ownership, where you have king, kabiyesi, oba holding the land in trust for the members of the community. You see that before you can transfer that ownership of land property, you must have at least two members of that community. Number one is the head of the community, that is His Royal Majesty or His Royal Highness or Kabiyesi or Oba or Baale, whatever the name they use, or Obi in the community in the Igbo land, or Igwe, whatever. The community, then the secretary of the community. Secretary of the community must, these two people must sign that document for customary ownership. One person cannot alienate it. So you need to take note of this now. One person cannot transfer ownership of where the community they have their land. Sometimes they will do partitioning, where every other members of the community will come together and say, okay, now we want to share our own. This is our own. This is our own. And with all those things now, you and the same Oniru chieftain's family. All those property are owned by this as a call. So now that will take us to another this matter, and which we talk about land tenure system. Land tenure system. What do we understand by land tenure system? Holding of lands. So Nigeria has a dual tenure system, and incorporating both customary and statutory tenure system. And they need to understand that most of these things are different. There are different ways. The Land Use Act attempt to harmonize this system by investing all the land in the states in the You understand? So when the before what resulted to the Land Use Act, before when government want to acquire land, they and be getting that power from the original family owners. No, those original family owners are meant to take power from government. So the military regime, they now decided to make the community and the family heads to vested that power in the state government, so that to they can be able to acquire land for public use. So all those things, that's why they acquire the state government, why they still recognize the existence of customary rights. That's why if you even if you want to apply for C of O, even land that is acquired by government, they will still ask for the deed. There are some things, receipt, family receipt, that shows that they still recognize the customary rights. Do you understand? So the two main types of individuals and family having the right to use and occupy a specific parcel. Transfer of land under customary is which are different in different zones. The law that are govern that customary law, and you go to um, customary law court to handle matters pertaining to customary land tenure system. So they also, some people call it transition. The government, whether federal of land title offering a greater, the major law there is the Land Use Act. So you need to understand the type of when you want to buy land and they want to. There are so many things you need to know before you covered by that. You need to understand those facts and prepare yourself, because that's the ultimate. Statutory, even if is finished securing their land, customary, performing the customary rights, like now in the eastern part of Nigeria, they will do what is called Ibu Ewu Ana. That's killing goats for 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 selling of land. In some places they call it drinking money. Some places they call it so many things. But whatever be the case, after that, you still go back to government. Most of us just say nobody is challenging us. No, you need to always understand the fact that you need to perfect your title document. So now, if you have not subscribed, like I keep saying, this presentation is coming up every Tuesday, and it's talking about property law practice in Nigeria. So please stay tuned. Any of the social media channels you can get hold of, Chaman Property Lawyer. In my Instagram, I use another name, Charles Chaman. But I'm going to circulate the link so that everybody will have access to that. But stay tuned wherever you are. This is specially made for those property developers, property investors, Nigerians in diaspora, who are desirous of entering into real estate business, or those that are already in real estate transaction. I'm going to talk about the key stakeholders in property transaction. Who are the key stakeholders? Several stakeholders play critical transaction in Nigeria, and each of them have their specific responsibilities and function. Who are those people? Have you asked yourself a question? Who are those key roles? Now, I want to take them one after the other from the highest authority. The number one authority of the states. The governor of state is the major key stakeholder in property transaction in Nigeria. The governor of the state, as the trustee of all lands in the state, the governor has the authority to grant the statutory right of occupancy. And this is further issued in a paper document called Certificate of Occupancy. And this is as an evidence of approval of transfer of ownership. The governor's consent we used to hear every time means that the governor has consented that this transaction from A has moved to B. So you need to understand this thing, very important. Governor of the state, without him, he cannot be able to have the statutory right of occupancy. So they must sign the document for you to have. That's what they call certificate of occupancy or governor consent. So perfection of title documents simply mean governor consent, registration, and stamp duty. So those are the things. Then what authority again that has is a stakeholder, the local government authority. They are responsible for granting customary right of occupancy in non-urban areas, that's rural areas, managing communal lands and regulating local land use and development. In local, you have local government authorities planning. So all these things are major to authority. These are governmental authorities. They now have individual stakeholders. They have governmental stakeholders. These are which they have already mapped out, like FCT. Like when you are talking about governor, so the same thing applies to governor of the in Nigeria, but they have the statutory rights like that of governor of the state of the federation. So the minister of the FCT administer the land use of the FCT. So now individual stakeholders and corporate stakeholders, who are those people? Number one, the third one, which is I mentioned the first one, the governor, the local government authority. The third one as the stakeholder is the surveyors. Surveyors, they have a licensed surveyors, and they are responsible for preparing accurate survey plans, which are essential for registration and obtaining a certificate of occupancy. These surveyors are land surveyors. So surveyor must come there and do land survey. They will do charting first. After the chart, do the land survey and register it at the state lodgement. I will tell you something. When they register a survey, the another major stakeholder, legal practitioners, generally, they play a vital role in property transaction by conducting a due diligence search, preparing and reviewing contracts for you, and facilitating the conveyancing process, and also ensuring compliance with the relevant laws and regulations. You cannot buy a property without a lawyer. It's not possible. You can't buy property without a lawyer. Any property you buy without a lawyer, just make sure that note that you are digging your hole, you are digging your grave. Yeah, that's the thing. It's not the threat, but note that because there must be a mistake. You use a lawyer, either that it's not advisable to use the seller's lawyer as a property, and you just sign. At the end of the day, you don't know the implication. So you need to understand this thing. And have lawyer, make one a friend. When the time reach, you call the plan. Inshallah, we can do pro bono for you. Lawyers are permitted to do pro bono service to their families and friends and well wishers. So take note of that. So they will take you through due diligence process to ensure that the property is good and genuine. Then the next is they will help you to draft the conveyancing document, contract or say deed of assignment, whatever processes. If it's a mortgage plan you are using, they will help you to perfect and do all this thing. The perfection of title is another thing. Getting the governor consent or getting C of O for you. Those are the things that lawyers will do for you. Then another stakeholder we can think of, you cannot underestimate, is estate agents. Estate agents, they are also called realtors. They call them estate agent, land agent, whatever name you call them, property consultants. These are professionals that assist people in buying and selling and leasing of properties. They will assist you, they will run around, help you make search, they provide market insight, they negotiate for deals and help clients navigate the complexity of the property transaction. So you need to know that If you want to buy property, you need to have an agent. If you want to sell property, you need to have an agent to help you to sell. These people, they are called realtors. They are brokers. They call them real estate agents. There are so many names you can use. Property brokers. They broker a deal. They act in between the buyer and the seller. They collect commission or brokerage. Usually 10%, usually sometimes 5%, depending on something, but subject to negotiation. There's no law that says it must be this percentage. Where it is not fine, the customs or the practice will set in place, or conduct of the parties. So they look at the traditional operation in the society and apply that. So please take note of that. These are the very important people you cannot underrate when it comes to property transactions in Nigeria. Then the next is banks and the financial institution. They provide financial resources for property purchases and development through mortgage loans and financial products. They have different packages that they use. They also play a role in ensuring that the property offers a collateral, meets legal requirements. You need to, so banks can help you to buy property. You see a property, you like it, root out. Banks cannot finance any property. Otherwise, you see, they are taking a great risk. They call it unsecured credit, and it's not collateralized. Well, even if it's collateralized, that collateral said it may be difficult for them to enforce it. They cannot be able to register it. They can't be able to perfect the mortgage. That's the thing. It does not have root title, and what the root title like that, either it is gazetted title or you have a certificate of occupancy or governor consent. So governor of the state, there must be a registration on that property. Must have a registrable instrument. So covering that. So please, those are the stakeholders we have in the property transactions in Nigeria. Now, what are the next thing is, what are the steps in property transactions? What are the steps? In property transaction, there are so many steps. A typical property transaction in Nigeria involves several key steps, and each of them require attention to legal details. You need to understand that. But please, before I go further to that, I want to also remind you and notify you that this program is specially made for my audience who are into real estate, or who are desirous of being in real estate or buying property or then, and those that are investing, those developers, those Nigerians in diaspora, those students in law schools, those lawyers out there that are not majorly in the property law transaction, estate surveyors and valuers, any stakeholders in property law transaction. These are the things. This program comes every Tuesday from 8 p.m. to 9 p.m. Sometimes it extends to 10 p.m., but it doesn't extend to 10. So please stay tuned every Tuesday. Subscribe to my channel, my YouTube channel, and it's coming live as you are seeing me now. It's online, it's live on YouTube, Instagram, and Facebook. By special grace of God, next week we'll be coming up on TikTok and any other platform I can think of, LinkedIn, but these are the platforms that I just think of love upon. And when by next week we are going to do better. It's just a program that we are starting up, and it's going to run from now till next 1 year, and at least I will take 1 year process to run you through all you need to know. And once you participate in this process, you'll be able to learn a lot in property transactions in Nigeria. Steps to take. Number one step, when you want to buy property in Nigeria, property search and due diligence. You need to understand that before purchasing a property in Nigeria, it is crucial to conduct a thorough search to verify the title and ensure there is no encumbrance or dispute on property. This involves checking the land registry, court records, and other relevant sources. If company is involved, check CAC to know the status of the company. It's very important that you know about this due diligence. Don't buy property without conducting a due diligence, and it is the responsibility of a lawyer to do that for you. Engage the service of a lawyer when you want to buy property. Pay the money for due diligence is very important so that it will uncover every information you need to know. There are some property that fall within government acquisition. And government acquisition has two types: committed and non-committed. If you fall under non-committed, sorry for your money. If it's fall under non-committed, it's subject to regularization. But you need to know this. And also, there are some other encumbrances that you can see on a land. Sometimes if you have a mortgage, a land is under a mortgage, and it has not been discharged, you buy, you cannot be able to get your rights there. You don't know whether that property will transfer to another person. These are the things you need to know. Then some lands are into dispute. Family are dragging the land, one individual or the other. The land is in court. Go to the court that has jurisdiction, the high court, and go and verify if there is any traces. Verify from localities, from individual around. Check the land registry. If there is any register, check the probate registry. So all these things are very important that you need to know. Anytime you want to buy property, it's very important. That's the first step. After you must have seen property that you like, you do this due diligence, and it's very important that you do that. So the next one is to negotiation and agreement. Negotiation and agreement. Once a suitable property is already identified, the buyer or the intending buyer and the seller negotiate the terms of the sale. You have to negotiate the terms of sale. A formal agreement is then drafted, and you have to outline the rights and obligations of both parties in that. That's where the contract of sale, deed of assignment, deed of conveyance, what a power of attorney for some state. Those are the places. It's very important. You need to know that. Then the next step is obtaining governor consent and perfection of title document. Obtaining governor consent is all about getting either you get C of O, deemed grants, or you get normal governor consent. But the most important thing there that the government of the state recognize that transaction. That's what we mean governor consent. For properties held under statutory right of occupancy, the governor must consent to it, and this is a prerequisite for transfer of legal interest in that property. This involves submitting an application along the necessary documents, including the deed of assignment or deed of covenant, survey plan, the evidence of lodgement, your ID card or whatever, your passport photograph, or so many other things that you need to know. So, and note that there are some transactions that have different documents to prepare, and most of those documents you must prepare everything. And during the process of this perfection of title document, you are going to have 3 stages. Number 1 is governor consent, obtaining the governor consent. Then 2 is stamp duty and registration. When they register the title, they will give you registration history. It's very important. So, and those stamp duties is relevant tax authorities that will take care of that in land registry. So, and those are the steps by step that you're going to. For some land that does not have root title, then issuance of certificate of occupancy. You need to have the certificate of occupancy as part of the process you get when you want to buy property that does not have a root title. Now, taking us to the next phase. I'm just trying to rush so that we will not exceed my designated time. Challenges in property law transaction. We have come to a place where most people will have questions. What are the challenges? There are a lot of challenges despite the robust legal framework. Property transactions in Nigeria are not yet without challenges. Just like every other business transaction. What are the common issues? We're going to look at the common issues. When you want to buy property, what are those common issues? Now, 1 is land dispute. Land dispute is Zoana and also I don't know what they call it in other language, but Igbo land they call it Zoana. Land in dispute. Conflict over land ownership and boundaries are very prevalent in society. Who owns this one? Who owns that? It often arises from overlapping claim from customary and the statutory right. Some people will say, I am the statutory right of owner. I am the one that has the statutory right of ownership. Another one will say, I'm the customary owner of this property. So this thing, overlapping of these 2 laws is major issue That's why in Lagos, you see on Western, you see some people, they call themselves Omonile, landowners. They are coming from the customary land tenure system operation. Why government is the statutory right of owner. So after buying your property now from somebody, you're getting government concern, you see one Omonile coming from somewhere or the and disturbing you. They will say you want to build a house, you must pay foundation, you must pay for roofing, you must pay for that. They are coming from the customary ownership. So this before you know, issue will come up. That's why it's good to perfect your way for customary and as well as that of statutory ownership, and verify if there's any dispute in land. Land dispute is something that if you enter court, it doesn't finish in 1 year. Sometimes 2 years, 3 years, 4 years, 5, 10 years, you still there. We have handled a matter that lasted, in fact, 14 years. By virtue of my background, my father is a lawyer. There was a matter I know that started 1991. 1991, I know how old I was. That matter in court till I graduated, I got called to bar. Just think about it. In fact, it took when he finished for high court, you go to appeal court, from appeal court to Supreme Court. Especially when they are now having interstate dispute too. When they are having interstate dispute, run away from that. Or when they are having family, different family, different community. That one is worse. Different community will be very difficult to settle it because it's not individual. If it's ADR mechanism buy the property, so it's major challenge is fraud and proper title. They will